Welcome, everyone. We're glad you're here. If you're here while we're doing this live, we're also glad that you are here if you were doing this on demand after our premiere of this episode. We are here to have a lively discussion with our panel on the topic of the nuts and bolts of lost profit cases. I'll do a few housekeeping things, and then after that, we'll dive into the discussion with our panel. So today's program is brought to you by Financial Poise that provides education for professionals, owners, executives, and investors. Today's program is underwritten. It's sponsored by National Law Review, our co-producer. It's a legal news website. A disclaimer. This is for general information only. This is not for any specific case. So if you're seeking professional, legal, financial, or other professional advice, you should consult your professional that you've retained. And also, the faculty are here to hear your questions. So if you'd like to pose a question, please feel free to reach out to any of us. I'll show you the slides that have our email information on them. Our speakers today are Megan, Matthew, Ben, and I am the moderator. And the bio slides are in your deck. Megan is an experienced valuation, economic, and financial and damages expert. She's based in Philadelphia. She's the principal of Dispute Economics. Matt is one of the leaders of Stastera Capital. They do underwriting diligence and monitoring and litigation finance. He's based here in Chicago. Ben is with Alvarez and Marcel. He is in the valuation services practice. He's with their Seattle office. And I am John Levitsky. I'm with HKA Global, based here in Chicago. And I focus on business valuation, economic damages, and forensic accounting cases. So let's talk a little bit about what we're going to talk about. We're going to talk about the nuts and bolts, and a lot of times these cases arise when there are disputes about why business doesn't go as planned. Maybe there's a disruption in a contract. Maybe there's an accident, such as a fire. Maybe there's a dispute with a third party, such as a lender. And the areas that we're going to talk about today include lost profits as an overview, how to prove lost profits, what's the role of experts, what are the various methods for calculating lost profits, and we'll also talk about some of the considerations in defending a case. In your materials, you'll see the slide deck is extensive. And there are numerous slides. I'm flipping through them on the screen. There are graphs, there are bullet points, there's some suggested recommended readings. They are helpful materials to facilitate understanding of the subject. But today we're going to hear directly from our panel. We won't flip through the slides, but we suggest that you have them available. You may want to take notes, or you may want to flip through them on your own for additional reference as we have our discussion. So with that, we're going to talk with our panel today. And Ben, what are lost profits?
Yeah, for sure. Yeah, so I'll kick this off. Probably starting around the slides 15 through 18 here. If you guys want to follow along there. But lost profits are damage remedy that a plaintiff can recover when a bad action by a defendant has caused the plaintiff to incur lost profits. Meaning lost profits are the actual loss sustained by the plaintiff that would have been generated had no loss event occurred. And I would say there's no real set way for measuring lost profits arising from a loss event. However, there are common elements in generally accepted practices and techniques of lost profit engagements that I know we will all be getting into today. Generally, if done properly, lost sales should be the foundation for the lost profit calculation. However, economic losses are not measured by lost profits, or they're not measured by lost sales, they're measured by lost profits. So you need to analyze the cost to generate that revenue. It needs to be addressed and deducted. So analysis of to determine the level of fixed expenses and variable expenses that would either continue or be saved because of the loss event. And so like fixed expenses, meaning our insurance, certain professional fees, rent, certain salaries, other non-discretionary items, those would not change with the reduction in sales, but variable costs would. So variable costs like cost of goods sold, transaction fees, certain hourly employees, the direct operating costs. So lost profits simply is lost revenue minus your saved expenses.
So Ben, is it sort of the incremental profits that for some reason have been impaired or eliminated?
Absolutely. And you could be, depends on what type of loss you're dealing with, right? Like if you have a complete shutdown, you're going to have a complete loss, and maybe that'd be a little more easy to calculate. But yes, you're absolutely right. It'd be the incremental loss for the deduction in revenue that you're associating that incremental profit to.
Well, thank you. Megan, we talked for a moment, we heard from Ben on what lost profits are. Are there some other types of economic damages? And if so, how do they compare with lost profits?
Yeah, there's a variety of different types of damages that really speak to how to put the plaintiff back in the position that they would have been in had the damaging act not occurred. So if you imagine like an asset misappropriation, simple repayment of the funds that were removed from the organization would compensate for that, along with some interest, perhaps, depending on the time period. Otherwise, you could have a property that's damaged and just compensating for the cost of repairing it. Those are economic damages as well. And then in some cases, depending on the claim, you have multiple forms of damages that are recoverable in the same situation or at the same time, such as intellectual property matters. If you have a copyright or a trademark dispute, it's possible to not only get lost profits, but if the defendant's profits from utilizing that information wrongfully are over and above the amount of lost profits to the plaintiff, you can recover that too.
Well, thank you, Megan. Matt, business performance can vary. So how do I prove, if I'm a business owner, that what my business is experiencing is lost profits and not just business variation? Are there some key elements that I need to demonstrate?
Yeah, I could answer that question as a legal matter or as a factual matter. Starting with the sort of legal framework at a general level, courts in the U.S. require, generally speaking, three elements or requirements. One, causation, which is to say, but for the wrongful act, this wouldn't have happened, or the wrongful act is the cause of the lost profits, or commonsensically. Two is that it was foreseeable, either depending on the jurisdiction and the formulation, either subjectively or objectively foreseeable, that a breach or a tort of this sort would cause such lost profits, such that, in New York, they say it's fairly within the contemplation of the parties when contracting, for example. So when the parties entered into their economic relationship, it was fair for the defendant to foresee or to expect that if it breached, that it would lead to lost profits for which would be held accountable. The lost profits suffered by the plaintiff for which the defendant would be held accountable. And then the third sort of element generally is you have to show the amount of, or be able to show the amount of lost profits with a reasonable degree of certainty, or with reasonable certainty. One watchword for defense lawyers everywhere is speculation. Speculation is the enemy of lost profit damages for anybody trying to recover them. And it's usually the first word out of the mouth of somebody fighting lost profit damages to say, this is just speculation. You can't show that the plaintiff would have actually made these profits but for the alleged wrong.
And Matt, and I got some questions for you on this in particular. So are you looking, when you work with experts like myself, a financial expert as the attorney, are you looking to us to prove causation through the financial records?
Usually, yes and no. You get into a little bit of a fuzzy line that honestly litigants in courts sometimes have to work hard to keep straight between liability and quantum of damages. So, the fact of damages is something that needs to be proved under, virtually every cause of action. But that can be established with sort of common sense or inferences or lay testimony or traditional evidence. Whereas the sort of proving up the quantum of damages to a reasonable degree of certainty is typically the province of experts, which I know we'll talk about later.
Yeah, I've found that we're, as the expert, the financial expert, as a CPA, we're not necessarily there to prove causation. We're assuming that liability occurred and that impact is what's causing the loss.
Right.
But I have been involved in numerous cases where we are being used as a tool to help support the causation, right? Like we can run certain analyses and do certain scenarios that show that when this event happened, then this occurred financially to help support the causation arguments.
1,000%, like a regression analysis, or for example, a sort of efficient market. I mean, this can get quite complex in the securities area where you have to identify causation from an efficient market. But you're right. Generally speaking, it's not necessary or even advisable to satisfy the element of harm or damage by recourse to an expert. Usually you can get that done just as a lawyer.
Great. Well, Ben, what about evidence? What do forensic accountants or economic damages or valuation experts look for as evidence to assess whether or not there are lost profits, and if so, how to quantify them?
Yeah, absolutely. So every case and situation is governed by the documentations, the facts, circumstances, and assumptions that are used to support the proposed lost profits analysis. The approaches, the methodologies, procedures, analyses, those items could specify what information is needed in a case. However, there are common items that we review frequently. So historical performance before and after a loss event, accounting documentation, your sales ledgers, your income statement, your balance sheet, your cash flow statements, operating information. Do they have prior startup success? Do they have industry experience? How long have they been operating? Operating results, working capital, cash flow, financing, structure. Have they achieved certain milestones? Then we would look at industry data as well, economic and financial information, market surveys, maybe official statistics, BLS, government statistics. We would look at other experts' opinions and testimonies that may influence the lost profit analysis. The list kind of goes on to contracts, letters of intents, business plans, forecasts, canceled orders, declarations, correspondence, kind of you name it, like anything that we can get our hands on to help support the lost profit claim. Basing your calculation on facts and evidence is the way I like to go. So getting all that information to be able to conduct a proper analysis and support it is the way I like to go.
Matt, how do you show, if you were trying to explain to, or your experts trying to explain to a jury that there are lost profits, how would they typically show that?
Well, a lot of the information and data that Ben was just referring to is obviously the stuff of proving lost profits at trial at a sort of frankly less sophisticated level. And if I'm putting myself in the shoes of a lawyer, meeting with a client early on, here's what we need, as a sort of high level, general, initial layman's matter. The plaintiff's financials, before and after, is something you would want to look at, in the first conversation or immediately. And that can include revenue, or will include revenue and or EBITDA. Some companies aren't profitable yet, so EBITDA will be less relevant, which obviously if they're not profitable, that creates issues for lost profit damages. But sometimes revenue is more relevant than other situations, in comparison to EBITDA. You certainly do need to account for costs, though. It's not, you'd be surprised at how often you see a damages analysis from a client or a plaintiff that doesn't realize that you have to subtract out the incremental costs that Ben was talking about earlier. You would also want to talk with the client about obvious or likely intervening factors. This is becoming less and less relevant over time, but how did your business do during COVID? How susceptible were you to COVID? Did you drop off a cliff in 2021 because the defendant breached this contract or stole your trade secrets, or did you drop off a cliff because your business was movie theaters? Projections can be gold, can be very, very valuable in cases like this, particularly if the defendant created or endorsed them, or if the parties generated them together. So that really makes life complicated for a defendant. Say it's a failed merger or failed business deal, or some sort of joint venture that falls apart, and the defendant says, there was nothing there anyways. This was going to be a dud. Your company wasn't, you didn't, there was nothing valuable here. This is all a waste of time. And then you present a document showing that they, 6 months ago were saying this joint venture was going to generate $1 billion. That's helpful as an obvious, intuitive matter. It's also helpful as a matter of law, frankly. So analyses like that can help with, for example, a new business that doesn't have a lot of track record. And then the other thing, maybe I should have started with this, is I would tell a client to hire an expert early and often. It sounds like pandering given the present company, but getting an expert involved at the threshold, at the beginning of a case is valuable. And oftentimes it's not very expensive. To the extent that experts become expensive, usually it's when they have to really, engage in the exhaustive, comprehensive, sort of rigorous analysis. But at the threshold, they can really help frame the analyses and also sort of level set and put you on understand what the sort of potential scope of the recovery may be, and also help you chart a path towards achieving it.
Well, thank you. And Matt, you use the term EBITDA. Would you share with our audience what is EBITDA?
I object. I'm the one non-CPA.
Earnings before interest, tax.
Earnings before interest, tax, depreciation, and amortization. How'd I do?
Right.
Perfect.
Very good.
Yeah.
All right.
Very good.
It's essentially, I may mangle this, but I've understood it over the years to be essentially a measure of profit without sort of extraordinary expenses or income, depending on how you define that.
All right. Well, thank you. Megan, would you like to add a little more detail about what kind of evidence might help establish what a plaintiff's profits would have been? And is there something called but for? What is but for?
Yeah, that's the crux of the lost profit claim. It is what revenues would have been achieved, and therefore what profits would have been achieved had the damaging act not occurred. And so, yeah, I listened to everything Ben was listing off, and it's like, it's very similar to a valuation engagement, because what you're trying to do is basically turn that whole set of documents inside out and get a feel for what this business does, what are its drivers of value, what types of events impact it, in comparison to industry and economic circumstances. Certainly, this is like the COVID scenario where you have to make sure that there aren't anomalies in your historical period, because you're trying to, if you can, use some of that historic information to project forward, because you have to use that to say, all right, I've seen that these relationships exist, these trends exist compared to what was going on with the competitors or the industry. And so maybe I can use industry data or a competitor's data then to project forward what would have happened versus what actually did happen. And the only other thing, I guess, as far as evidence that I didn't think Ben mentioned, was one thing I really like to do is make sure to read all of the deposition testimony, and even to help counsel prepare for the depositions, because sometimes, in evaluation, what would we do? The first thing we would do is interview management, right? To gain that kind of inside knowledge that's between the lines, if you will, of the financial statement. And in litigation, you don't often have that opportunity, particularly if the business owner is on the other side of the case. So what you need to do is get counsel to help obtain that information for you through interrogatories and deposition questions. And then the information that comes out of the depositions ultimately, needs to be incorporated into the analysis.
Well, thank you. Ben, you gave a lot of detail, and Matt and Megan added other things that would be considerations from an evidentiary perspective. We also heard a little about comparison, like before and after, and trends. So is it always the case that you look at the history of a business and its future expectations are the same? Do the forecast always look like the historical trend? And what happens if the lost profits claim is not in line with the historical performance of the business?
Yeah, absolutely. Yeah, you can certainly have situations where the historical results are inconsistent with the lost profits claim and analysis. The interesting and challenging aspects of this work is looking into that crystal ball and determining that, but for this loss event, sales and profits would have been X. And that is based, again, on the facts and circumstances of the case, the business, economy, the industry. And there are just so many factors, internal and external factors, to consider when preparing lost profits claims, that the historical performance may or may not be indicative of the but-for world. And I'll give some examples. Like, for example, a large contract ended just prior to the loss event, or would have ended during the loss event, and the company would have experienced a decrease in sales whether or not the loss event occurred. So therefore, using those inflated historical results would be inconsistent with the proper loss profit calculation. And conversely, a company landing a large contract and suffering a loss before the contract starts to take off and pay off, historical results would not capture that increased revenue that would have happened before the loss event. And there's I have other examples. Let's just say, for example, you have a large basketball tournament. We have one coming up this month, and it's going to be held in and around the impacted business. And but for the loss event, the company would have seen a spike in sales, just like the rest of the local economy experienced. So, think of like a hotel being 100% occupied versus historically, being 50% occupied during this particular week or month or whatever. And so, using historical results would be inconsistent in that case to project the profits for the impacted period. We've talked about this a little bit. Other answer is using a base period that and ignoring the impacts of COVID, both positive or negative. That could just result in too high or too low of an average that you're using to project your future sales off of, your but-for sales off of.
Well, thank you. Megan, you'd mentioned that looking at what drives the success or the value of the earnings of a business, maybe a significant part of the analysis. So with that, is there evidence that may be helpful to identify and eliminate whether there are other potential causes of the lower profits? For example, a company could have operated through COVID and they still could have had a lost profits claim that may have been unrelated to COVID. So is there certain evidence that you may look at as potential other causes and eliminate those?
Yeah, and actually, this is what I was going to add when I was thinking about it earlier when we were talking about causation. I agree wholeheartedly that most of the time, the legal portion of causation is a liability issue, but from a damage expert's perspective, you do have to consider causation too, because in effect, that is the elimination of all of these other intervening factors that could have actually been to blame for a portion of this loss that's being claimed. And in particular, if you've got multiple claims and different damages associated with different, maybe you've got a claim that only relates to one component of a contract, you have to make sure that that's segregated in your analysis so that if the trier of fact decides that they don't get that they still have a number to work with. But back to your question, John, the actual information, you really have to think about it from the perspective of the opposing expert. You've got this idea in your mind of this, how it should have gone, but then you have to turn it around and say, what are all the questions I can think of that I would ask if I just was looking at this report and was on the other side? What about this? What about that? And you have to be aware of what's going on in the industry and the economy very much. Maybe there are metrics that would affect that company in particular, like if they were over leveraged and then interest rates increased substantially. There's a lot of potential intervening factors that need to be considered, but basically, as long as you can address those in your report and include information and say, yeah, I considered it, and it's either been dealt with through some sort of a allocation process or, it determined it didn't have an impact. The other thing is, again, with the deposition testimony, you have to make sure that you're aware of what your clients have said and opposing clients have said, because whatever the parties are saying in the depositions might differ from what they've said in an interrogatory response, for example. But if it's a 30B6, that's ultimately the word of the company. So you have to use that information. And, maybe the business owner says that they're planning to retire in 2 years and they had no succession plan. Well, you better not be using a 5-year damage period. There's just like a whole lot of pieces of the puzzle to put together to make sure that you've got a reliable answer at the end of the day.
Well, thank you. Matt, you'd mentioned earlier it can be helpful to retain an expert. So when is a good point in time to hire an expert? And then what does an expert bring to the table, say for the court or for the client?
I think it's a good idea to hire an expert at the earliest possible opportunity. And I often tell, litigants or counsel with whom we can, interact with Cetera that experts will oftentimes be willing to, take a look at your matter and give some initial thoughts, right away as almost a business development measure, so as to position themselves to be engaged to do the heavy lifting when the time for that comes. So there's very little good reason not to reach out to experts at the beginning of any sort of significant case. It's much more valuable than you would have to pay at that phase of the case, in my experience. And the reasons to do that are are, many. When you get, if you fast forward to trial, which a lot of great trial lawyers do, you start thinking about trial the day the case comes in the door. You start writing your closing argument on the first day of the case. The reason to have an expert at trial is, well, there's a technical legal reason, which is most witnesses aren't allowed to give opinions at trial. Only qualified experts can give opinions. And while a lot of economic expertise and analysis sort of, walks the line between opinion and fact, it's helpful to have that leeway and to have an expert who's authorized to provide opinions to the jury instead of not being able to have that. Experts, like Ben and Megan, as the audience no doubt is discerned already, are very good at explaining complex information and complex topics in a way that's understandable by a jury. As a backstop to an expert or as an alternative, you could have the company CFO carry the water, right? And in my view, sort of somewhat in the same vein as what Megan was just talking about, it's helpful to have, where possible, a lay, an employee of the client be capable of providing the economic analysis just in case the worst happens and the expert gets excluded from trial or for some reason falls out of the case. So you don't have a total failure of proof. It's good to have a backup for your expert in the form of a lay witness if necessary. But that's pretty rare. And assuming that doesn't happen, an expert is much better at explaining complex concepts to lay people like juries than the typical, in-house CFO or what have you. And they know how to synthesize a lot of data and digest it and convey it to the fact finder in a understandable fashion. Also, experts, typically if you watch an examination of an expert at trial, for legal reasons and for persuasiveness reasons, they'll spend quite a while qualifying themselves with their credentials. Usually experts are very impressive, including this group. So a jury will be impressed that you have, somebody with all of these degrees and has written all these papers and has all this experience, and therefore really pay attention to what that person says. And they also have a patina of objectivity, as opposed to an in-house employee who is obviously has a biased interest in the plaintiff prevailing. So all those reasons are underlie the almost ubiquitous use of experts at trials when it comes to damages in particular. For the client, experts are great too, because as I think I alluded to earlier, it helps to set expectations and sort of scope a dispute early on. This client may have unrealistic or misguided expectations about what's recoverable. For example, the revenue versus profit issue that I mentioned earlier. And the expert too can help synthesize an enormous amount of information for the client in a way that a client may not be able to do. And apply sort of rigorous standards that are informed by law and extensive experience to educate the client and help the client understand what the likely value of the claim actually is, which in turn is valuable, if not even essential, for settling a case. Because the plaintiff has to have a reasonable and realistic expectation of the value of the claim in order to, in almost all cases, needs to have that in order to have a meeting of the minds with the defendant, who themselves is doing a sophisticated analysis of the value of a claim. So those are all the reasons why experts are so important and frankly ubiquitous in any major litigation in this country.
Yeah, and I'll just piggyback off of that, John, and just keep rolling with this one. So, Matt, I 100% agree. And your comment about engaging the financial and accounting expert early in the process, that's advice we give everybody we can, because you're absolutely right. We can aid in the discovery process. We can request and analyze information up front. We can help strategize, provide questions for depositions, cross-examination. And from a good expert, they're going to provide very pointed advice that is objective, right? Like you said, just to level set the case up front. Like, this, you have a claim or you don't have a claim, or we've seen hundreds of these, and this is where you're going to be headed. The expert's going to provide and use the proper methods, and rely on the proper evidence and help gather that proper evidence. And so for me, just, this question and answer about, when to retain an expert and what you should expect from the expert, it goes beyond just the technical capabilities and the educational and work experience. A good expert is going to be honest and thorough from start to finish in a case.
Well, thank you. Megan, let's talk about credentials. We heard about credentials. What are the credentials and expertise that a party might want to look for in a forensic accounting expert to compute lost profits?
Well, there are various credentialing organizations out there, and there are many people who start out with a CPA and go from there. I think that depending on the claim, a CPA is a very good choice, because if you have issues that relate to GAAP compliance or tax exposure or regulatory requirements, those type of things, you certainly want always somebody that's the best fit for your claims and for the type of analysis that's going to be performed. So if you're talking strictly lost profits, I think, like Ben and I have both kind of alluded to, it's the analysis is really similar to a business valuation. It's just for a shorter period of time. So I think in that circumstance, it's really advisable to get somebody that is credentialed in business valuation, because we have standards that we are accustomed to complying with in the development of a valuation engagement. And somebody who is not maybe trained in that regard wouldn't necessarily have that I guess it's almost like a bullet point format of how you go through an analysis, that it's just a methodology that you employ pretty much every single engagement. And
Are
so
there some
thing you
professional
mentioned-
standards? Go ahead.
One thing you mentioned there, Megan, that I just think really just hit me is just that what I've seen in my experience, I've been doing this for like almost 20 years now, is I started out as pure forensic accountant and didn't know anything about business valuation. Then I moved into the business valuation world about 15 years ago. And it's just the overlap between forensic accounting, just pure, simple lost profits, say like your loss of rents calculation, something like that, towards your, like you said, lost profits, essentially business valuation just for a shorter period of time. Just having the ability I feel like there's a lot more crossover now between business valuation and economic damage, that they're very much becoming commingled. And I think it's very important for the expert to have expertise and experience in both worlds.
I've observed that too and experienced that too. I think more and more when a lawyer is explaining damages, the various measures of damages that are available in a case, they lead with or emphasize diminution in value of the business or destruction of the business. The small company suffers a devastating blow and then goes out of business. Just out of curiosity, how do you think at a high level about the distinctions between lost profits and destruction of business, or diminution in value of a business? Because my understanding is oftentimes business valuation is just applying a multiple to the EBITDA. Is it as simple as that, such that the two sort of equate to each other, or is this maybe a pretty complex question that we need to have?
Yeah, I'm sure Megan has given presentations on this as well, but given numerous presentations where and in those presentations it talks about lost profits and business valuation. We'll go through the business valuation methodologies. You got your approaches, your market, your cost approach, your income approach, and your market approach. And you're talking sort of like a market approach using a multiplier. But we talk about sort of like the slow death, right? Can you have lost profits and lost value? Can lost profits be greater than the lost value? And I think there are certain circumstances where you do have kind of like the slow death of a business. And so you're going to have lost profits for a period of time, and you're going to have the diminution of value. But yeah, I think it is complicated because you're going to be looking at various methodologies and approaches in business valuation for one side of the equation, and you're going to be looking at generally accepted principles and practices for damage calculations. And Megan, I'm sure you have more to add to that.
Yeah, I mean, I can weigh in on that as well. I think there's crossover because the methodologies for the lost profits claim is still going to be essentially a market approach in your yardstick method. And I know we're going to probably get into more depth on methods, but the necessity to develop a discount rate, that's your income approach, your projections and your discount rate. So you can run the analysis simultaneously. One of the major components that is a differentiating factor is if there is no end to the damage period, then it would be considered a destruction or diminution claim. But in a valuation, a measure of the value of the business that is lost, taxes are taken into effect. And in a lost profits calculation, they are not. And so you could have a 10-year lost profits period in which the lost profits exceeds the total value of the business because you're talking about apples and oranges, essentially.
I'd also like to have a whole nother seminar with you two about the appropriate duration for a plaintiff to seek under various circumstances, which I find to be a challenging issue in virtually every case. But maybe we can talk about that more later.
Yeah, that'd be great.
So this is a good prelude to talking about methodologies. We talked a little bit about getting a before and after picture. We talked a little bit about projections and revenue, and Megan mentioned yardsticks. So Ben, what are the most commonly used methodologies for quantifying lost profits?
Yeah, I'll quickly go through the commonly accepted methodologies, and I know Megan's going to go more in depth in each one of them, but I'll just kind of give an overview of them. So the before and after method, you look at the periods before and after the loss event to help establish a basis for what would have happened during the loss event. The yardstick method, this method uses guideline companies or industry measures to serve as a proxy for what would have happened but for the loss event. And then you have your sales projection method, which Matt and Megan have talked about a little bit as well. So this method uses company-specific forecasts, preferably one that was prepared during the ordinary course of business, or for some purpose other than the litigation. Litigation prepared forecasts are viewed as being self-serving and being a biased source, and it just could be difficult to defend. Then you have your market method. Generally, this is not used as often as the first three methods, but it aims to establish the plaintiff's market share prior to the bad act and applies the company's specific market share to the overall market size during the loss event to estimate the but-for sales. So those are the four common methodologies, and there's certainly other methods and ways. This is by no means a comprehensive list or the only ways to measure damages, but they are the most recognized methods. The method that is selected, however, needs to be reasonable, relevant, and reliable. And it's not necessarily you pick one. It could be a blend. It could be you're looking at coming at different angles with multiple methodologies. But I'll leave it there, and because I know Megan's going to dive into more charts and graphs and things like that for this.
So Megan, we heard about a handful of methodologies. How does the expert pick which methodology best fits which scenario?
It ultimately comes down to what data is available. You have to put forth the most reliable answer. So if you can run multiple analyses under various methods, incorporating as much data as possible, then you're triangulating in a way. You're really providing the most supported position by having looked at it from not only the market angle and the yardstick angle, but you compared that to what the company was doing historically, what they're doing now. It all seems to fit together nicely. That's best case scenario. But the reality is you're not always going to have the correct data to run all of these analyses. Small privately held companies hardly ever develop projections in the ordinary course. It's just kind of not something they waste their time on, I guess. Even a 1-year budget is hard to come by in most cases. So it depends on the size of the business you're dealing with. And, certainly a cell phone manufacturer, for example, might have market share data. But if you're dealing with the pizza place at the end of the block, you're going to be hard up to find that kind of information. So you just really have to be creative, use these as a guide, and then come up with the best possible and most supported data you can, and whatever is considered the best available evidence.
Ben, does the age of a business or the stage of its development make a difference about what sort of damage measurement approach might be used?
Oh, yeah, absolutely. Yeah, rationally, a new business damages may be perceived as being speculative compared to an established business. So, therefore, how can lost profits be proved with any reasonable certainty for, say, a new business? To take it further, the reasonable certainty test has had clear parameters. Profits which are largely speculative, as from activity dependent on uncertainty or changing market conditions or chancy business opportunities, or promotion of untested products, or even entry into unknown or unviable markets, or the success, if its success is hinged on unproven enterprises, then lost profits can't be recovered, or it's going to be very difficult to prove it, right? Like, I think that's, we're getting to the word speculation, like Matt said at the beginning, like that's you don't want to start there. So therefore, the factors like these and others make a business venture risky in prospect, may preclude recovery of lost profit in retrospect. However, though, that thinking that I just laid out, it does appear contrary to the real world business, right? Like, investments are made daily into businesses, many of which are for unproven enterprises with the expectation of risk adjusted profits, right? Like, they're making investments with accounting for certain risks. So I think over time, though, courts have acknowledged that the new business rule is no longer like a hard and fast rule. It's moved from a legal rule, and Matt, you can correct me if I'm wrong, but it's no longer like a flat out no, but it's now moved towards this evidentiary issue, and lost profits can be awarded to and for a new business as long as the lost profit analysis meets the reasonable certainty test. And I think that kind of goes back to everything we've talked about. As long as you're staying away from speculation and you have a contract in hand, and yeah, we were a new business, but we had this contract, but for this event, like, we would have executed it. The people we had in place, they have years of experience in this space. We had everything lined up. We were good to go. But for this one event, we would have been able to execute this. And that's, to a reasonable degree, we would have done that, right? Like, I think that's the measure. I would love to hear from an attorney and get a rating on how that answer panned out.
That was an excellent answer, Ben. I am an attorney and play one currently on TV. With the caveat, as always, that it depends on the jurisdiction. the new business rule is a rule, as you indicated, that's evolving, and different jurisdictions have different quirks in the way that the extent to which it's applied. But I think you have correctly identified the trend, and I referred earlier to the fact that I think at least in a couple or a few jurisdictions, there's been an increasing acknowledgement that when you have the defendant signing on, contemporaneously to expectations about what was going to happen in this new business, that can be a very useful way to get through the business the new business rule.
Mm-hmm. Yeah, speaking to that, my brain is going in a tangent here. But yeah, like conversely though, if you're the defense and you guys help prepare a forecast, that could be very helpful too to defend versus so you have the plaintiff is now saying, we have this litigation forecast is going to be a rocket ship, but like you mentioned, the parties had created a forecast prior to litigation, and it had a more reasonable expectation of the business opportunity. That could be really helpful too from the defense side for using the projections.
Yeah, I think that gets at something really important, and which I don't know if I'll have another opportunity to say, which is, in our position, I work for a litigation finance firm. We're pitched on cases all day, every day, and people tend to get very carried away with lost profits when they're contemplating cases. And being sober and measured about your theories and arguments about lost profits is critical. It's surprising how often we'll hear that a small two-person company would have been the next Google but for X, Y, or Z. We were going to make $1 billion because look, that's what happened with Google. So if a defendant has projections that are favorable but not stratospheric, then that's actually maybe helpful for both sides, because when a plaintiff gets carried away with its lost profits arguments, I think it does real damage to itself. You start to get into a problem of just sort of common sense and windfall problems where whether it's a judge or a jury, they're just not going to award some guy in his garage or gal in her garage, $100 million because they would have been the next, NVIDIA. So it's important to remain grounded and sober and realistic when talking about lost profits.
Yeah, I can't tell you, as being on the defense side as the expert, just how many plaintiff claims that I see that are just, they were going to have their best year ever.
Yeah.
Just so frequently.
Hockey stick growth. Even
see that? Yeah. Just like unrealistic. Yeah.
Never grown. Yeah.
And when I'm on the plaintiff side, I try to stay away from that, right? Like I want to make sure that my calculations are based off of reasonable trends that we're seeing either in the company with their historical performance or in the industry, looking at industry, trends as well.
Well, thank you. Megan, we talked about a lot of things. We used the word cost a few times. Are costs taken into account? And if so, how does the damages analyst take cost into account?
Yeah, typically in a lost profits calculation, you're determining the incremental costs of that additional sale or that additional dollar of revenue you're saying was lost as a result of the bad act. So, a starting point for that is generally going to be the cost of goods sold, because if it is tracked separately, those typically are the costs that move directly with the revenue. But there are additional costs, usually buried in operating costs, that will be variable to different extents. And sometimes it's like threshold levels. So if revenues decrease by half, they can let go of 2 individuals. But if they don't, they still need those people because they have to cover, all of the shifts or whatever it may be. You've got to look through each and every individual line item to determine what impact it might, a change in revenues, and the change in revenues that you're projecting happened actually would have an effect.
Could there also be avoided costs that might be somewhat of an offset, or could there be additional costs in the form of like remediation or mitigation that get included in the claim and added to it?
Oh yeah. I mean, the cost of mitigation are really something separate and apart. And it's always advisable to track those separately, because if a different account is set up for them, it's not really part of the operating structure of the company. It is going to be a extraordinary expense line item that we would want to normalize if we're trying to create those projections. But it is recoverable because the plaintiff was doing their due diligence, essentially trying to limit the amount of damages that occurred. And maybe they had to, in order to do that, rent an additional facility or an alternate facility while their business, place of business was brought back up to code, or whatever the case may be. Sometimes incurring additional costs limits the lost profits. And as long as that's the intention, the mitigation expenses are generally recoverable.
Thank you. So as we come down to the last few minutes, first, we appreciate everybody sharing their insights on the panel. Matt, we wanted to ask, how is a lost profits claim typically defended against? Whether the defense is successful or not, is there a burden of proof? Are there some defenses?
Yeah, there are, and I think we've sort of been talking about the responses to the defenses as we've gone, in part. But yes, there is a burden of proof typically on the plaintiff to demonstrate damages with a reasonable degree of certainty, which is what we've sort of been speaking about so far. One issue as a legal defense matter that we haven't mentioned yet, but is actually very, very common in commercial litigation, is a contractual clause that says that a non-breaching party or a plaintiff cannot recover consequential damages or indirect damages. And then they'll have a parenthetical and it says, including e.g., and this long list of things, and it'll say lost profits. And this formulation is incredibly common and bizarrely vexing to the American judicial system, because the defendant in every case says, look, it says right there, no lost profits. You lose, you can't bring lost profits. But then the plaintiff's attorney says, no, it says consequential, you can recover direct damages, but not indirect or consequential damages. And it's talking about lost profits when they're consequential or indirect. In other words, if the lost profits are direct damages, they are recoverable. And this yields so much motion practice and arguments with courts. And to my eye, not a ton of, it should be a pretty simple, it should play out simply in each case, but it doesn't. And I think what it ultimately reduces to is the degree of reasonable certainty, which we've been talking about all along, and foreseeability, as opposed to their antithesis, which is speculation. If you're saying I was going to be Google if, Acme hadn't breached this contract, that sounds speculative and pie in the sky and consequential and indirect, because X, Y, and Z would have had to happen in order for you to become Google. Whereas if it's, if you had provided the widgets, then I would have put the widgets into my widget and sold it to this buyer who had already asked for it, then those profits seem awfully direct. So in any event, the contractual clauses talking about lost profits is an area of a lot of litigation in this space. And if you're a defendant, you almost always take a run at it because judges mishandle the issue regularly, in my experience. You would also attack typically the expert's methodology. Sometimes, not usually, the expert's credentials or qualifications, but more commonly their methodology. That should be unlikely to succeed if the plaintiff knows what he's doing, or if they hire someone anywhere near as good as Ben or Megan. And there's a fuzzy line between fodder for cross-examination and criticisms that rise to the level of insufficiently reliable techniques to be admissible before a fact finder. And then I guess the last one I'll mention is something I alluded to before. It's just kind of the gut test, the common sense test, the windfall factor. I don't think anybody likes a windfall. So if you're, awarding this small company that's never been profitable, if you're a plaintiff's lawyer asking that they be awarded $200 million, I'm not sure that's a sound strategy. And the defense will certainly make hay out of the sort of the cynicism of that, or the opportunisticness of that.
And Matt, I think you're forgetting one very crucial point and item here is hire a expert to help with the defense.
Goes without saying. I'll tell you, when I came out of law school, I was predominantly surprised about two things after about a year of practicing, now almost 20 years ago. One was the prevalence of binders, a lot of binders in law firms, although maybe less so as new generations come in. And
Banker boxes.
Two was the pervasiveness of experts in American litigation. And I'm not sure a lot of lay people realize this, and even law students. Experts are a critical part of high stakes, even medium stakes, even low stakes commercial litigation in the U.S. So I take it as not needing to be said, Ben, that both sides would have excellent experts.
Well, thank you, Megan. Thank you, Matt. Thank you, Ben. Thank you to our audience. We appreciate your insights. Our panel, we thank you. Our audience, we also appreciate your interest. We look forward to seeing everyone another day. And to our audience, we look forward to seeing you on another Financial Poise program. We have a website, financialpoise.com, and we encourage you to look for us in the future. Thank you very much again. And this concludes our program. Take care. Bye-bye.
Thank you.